Good afternoon, everyone, and thank you for joining us. The panel today is going to address an interesting topic that is often taken for granted, but hopefully won't be taken for granted after you listen to what we have to say today. The colleagues joining me are Alan Levine from our litigation department, Donna DiMaggio Berger from our community association department, both of whom work out of our Fort Lauderdale office, and David Ramsey, who works out of our Morristown, New Jersey office. All very experienced community association lawyers and in Alan's case, litigator. And we really want to get into some of the things that you frequently overlook and don't pay much attention to when you're confronted with what is invariably a form contract for a vendor. I also want to be clear, what we're talking about are service contracts. That could be your lawyer, your management company, the people who do the elevator inspections, the people who trim your trees or mow the lawn or treat the pool, the uniform supply companies, the security company. We're talking about contracts other than construction contracts for major projects. So that's where I want to focus our discussion today. With that, I want to start by asking Laura to submit our first poll question, and we'll allow about 20 seconds or so for people to respond so that we can then proceed with the webinar. For those of you who don't see it yet, the first poll question is whether your board has signed or renewed a contract in the last 12 months. And again, we're referring to a service contract. And as expected, basically all of you have, 91%. If only we could get 91% consensus on most other questions we ask. Okay. Well, the information to glean from that, Donna, is obviously that people are signing these contracts all the time. When a client has the good judgment to send you one of these contracts before they sign it, what are the things that you look for? What are the initial thoughts that you share with the client?
Well, Ken, the first thing I do is I start out asking a few questions of the client before I just dig into the proposal. I know some attorneys may just get the contract and away they go, but I need to know a little bit more about the contract, about how we got to the stage where it's being sent over to me. So some of the things I want to know is number one, has the board obtained competitive bids if they need to for the particular agreement or the service? I want to know if the full board has met and has discussed this proposal, and if they have selected this particular vendor or contractor and they're sending it over to me, or if perhaps it's just one board member that likes this particular proposal and is sending it to me. That's important. I also want to know if there's any potential conflicts of interest with this potential vendor or contractor. I can't tell you how many times I've asked, well, is anyone on the board related to this company, own this company? And sometimes the question is, oh yeah, it's the president's company, or it's so-and-so's, or it's their nephews. I want to know those things. I also want to know if the management company, if this is an affiliated company to the management company. I want to know if they've done their due diligence before they send me the proposal to start revising. And by that, I mean, have they checked out to see if the contractor has an active license? Have they asked for references and contacted those references? Have they found out if there's any administrative complaints that have been filed against this particular contractor? And sometimes, Ken, once I get through that conversation, remember, I haven't even looked at the contract yet. Sometimes I'll get the answer, you know what, this is premature. We're going to pull this back. Don't look at it yet. We'll get back to you once we do these things. Now, assuming we've cleared that hurdle and we get past that, yeah.
Before you go into the contract, have you ever had a client send you a contract to review when they've already got an existing contract with somebody else?
Oh, absolutely. They haven't canceled the first one. That's a whole different conversation that you may wind up paying double here unless we can safely extricate you from the first contract. But assuming we get past that conversation, then I'm going to dig into the meat of the contract. I'm going to look first to make sure that there's no mistakes, that the names of the parties, I can't tell you how many times the names of the association, particularly in large master communities, they've got the wrong association named in this contract, or the contractor's name is incorrect. And I'm sure Alan's going to talk about this later in terms of enforcement, but we want to make sure the contract is between the correct parties. So I look to see if there's any mistakes, and then I look to see what I call my deal breaker clauses. Now, I know sometimes attorneys get a bad rap that we're looking to blow up deals. I can assure you we're not looking to blow up a deal, but there are certain provisions that are deal breakers, in my opinion. Some of those include a non-cancelable contract. I'm sorry, I can't allow a client to enter into a contract that they can never cancel. Another provision is just overly complicated termination provisions, unreasonable or lacking indemnification provisions. A lot of these boilerplate contracts can just have what we call a unilateral indemnification, which is our client is indemnifying them against all the bad things they're going to do. Or if I come across an indemnification provision that is just going to be an impossible hurdle to overcome. If an insufficient warranty provision is there, that's going to be a deal breaker. And lastly, for a personal services contract, I really don't want it to be assignable because my client's doing business with a particular contractor or vendor for a reason.
Donna, one of the things, go ahead, I'm sorry. Go ahead, Dave.
That's all right, Alan. So Donna, when you first get that contract in, and it's probably just going to be a proposal from whoever the vendor is, do you also, and I know what your answer will be, but do you also check with the manager as to whether there was an RFP connected to that contract?
Oh, absolutely. And by RFP, David, it's a request for a proposal, and that's when the association sends it out. And you want to make sure that that contract ticks off all those boxes in that RFP. So for sure.
Donna, I know I'll get into how to safely extricate yourself from a contract in a moment, but one of the things that I smiled at when you were talking about it was indemnification provisions. What I have found is people use boilerplate indemnification provisions, and not only are they bad for the client, they don't make sense. People don't understand them. And so I'm asked quite often to review the indemnification provisions. And the first thing I say, and I find this even with lawyers who have been doing this for a long time, they have no idea, their eyes glaze over about how an indemnification provision is supposed to work and what it's supposed to say. So right. I'm glad you raised that.
So Alan, we're using a fairly big legal word, indemnification. For the folks on the call who may have heard that word and they have an idea, what are we really talking about?
So generally speaking, when you hire a manager, the manager is acting in the course of his agreement or her agreement or the company's agreement. And if they get sued or a claim is made against them, when they're doing the right thing and they didn't really do anything wrong, they're not being negligent, they're not disobeying any criminal laws, or not doing something that is horrible, the association should indemnify them for the claim that's made against them and the attorney's fees. But there are mirror provisions that have to go along with that, where when the contractor does something wrong that gets the association in trouble, where the contractor should be indemnifying the association. That's when someone, a third party, makes a claim against the association and makes a claim against the contractor, but the association really had nothing to do with it. It was really something really silly that the contractor did. And those can be just to pay the claim. They can be to provide a defense, that's a lawyer to defend them. The provision can provide that the association has a right to select the lawyer, but the contractor or vendor has to pay for it. Those are complex provisions.
Well, the indemnity issue is complicated, but it's a vital provision of the document, particularly with a vendor who could conceivably do something that creates a problem for you. And Donna, you're going to get into indemnity.
Yeah, I just want to say, look, what I'm looking for is fairness, what we're all looking for in these contracts. When we have a unilateral indemnification, a one-way indemnification where it's just the contractor or vendor saying, association, you protect me, I'm not going to return the favor, that's a problem. With a mutual indemnification, the easiest way I explain it to clients is, if we do something bad and get you sued, we'll protect you. If you do something bad and get us sued, you'll protect us. And I know we're going to get into that later.
And two quick comments before we move on to some of the contract details. Number one, David and Donna referred to RFPs. There are different requirements in different states for when a bid is required for a contract. But in my opinion, whenever you can get competitive bids for a contract, it's a good thing to do. It's good business. And it's good to be able to say to your owners when you approve a contract at a board meeting that we've looked at different contractors and got competitive bids. As far as indemnification, which again, we will revisit later, there are different kinds of contractors in terms of what indemnification is fair. There's a difference between indemnifying the guy who comes to treat the pool or clean the gutters, as opposed to, say, the manager who is an extension of the board and literally sits in the office and is your frontline person to deal with your owners. But we'll get into some of those details later. David, I want to turn to you. I'm going to ask Alan how to prove cause to extricate yourself from a contract. But I wanted you to describe some of the details you look for, both in terms of the obvious ones, like the materials and services to be provided and the price terms and the payment terms, but also some of the things that are typically considered boilerplate. What do you look for? What are the triggers for you?
So, of course, in each type of contract, it's going to depend on the nature of the work being done. But let's take an example, and you can pretty much extrapolate from this answer and apply it to any number of different situations. So let's say we're talking about landscape maintenance contracts. Whether you're in Florida or New Jersey, you're going to have a landscape maintenance contract. So I would have said snow removal, but you don't have to deal with that in Florida.
No, not that often.
So of course you're going to want to make sure that there's lots of details. Now, we mentioned RFPs, and very often a manager will have sent out an RFP that will contain a lot of these requirements for details. But maybe, as Donna said, the vendor proposal doesn't contain these details, or maybe the manager didn't send out a request for proposal, and now we're simply getting this proposal from a vendor, a landscape vendor, and he's got some basic stuff in there, but there's not a lot of detail. So what are we going to be looking for in that example? Well, we're going to be looking for everything from application of fertilizer and chemicals, and when are those going to be put down, and is the contractor licensed? At least in New Jersey, you have to be licensed for applying certain types of chemicals to a property. Is he licensed? Is the landscaper going to be subbing that work out, subcontracting it to a third party? If so, who is that third party? And are they going to be bound by the same terms of this contract as the contractor is? How often will the lawn be cut? I know this is all very mundane, but how often will the lawn be cut? And are they going to cut it on Monday, Tuesday, Wednesday, Thursday? Everybody wants their lawn cut before the weekend, right? So, you want to make sure that's things like that covered. How many people will be devoted to the site? How many will actually be working? And will there be someone there to supervise, who speaks English, who you can communicate with at the site? So you're going to get into these kinds of details. Of course, you're going to get into pricing. Sometimes, at least in my jurisdiction, we see landscape contracts where you're paying the total cost of the landscape contract over 12 months of the year, even though in New Jersey, landscape contractors are only working from mid-March to maybe mid-November. So those are important terms, because maybe it gives the association the ability to spread out the payments a little more than they otherwise would. So, those are the kinds of things. And we all talked about earlier on, it is the proposals that should never be signed that the vendor provides, because that proposal is always going to be in the vendor's benefit, is also often going to be lacking not only those details, but many others that we'll get into with regard to insurance and, of course, indemnification and on and on. So those are the kind of things that, I'm going to look for. If it's a security contract, similarly, how many people are going to be devoted to that work. We also want
David, what
Yes.
you're describing are all the business terms. And it's interesting. Yes. I'm fascinated by what you're saying, because with most of my contracts down here, it's the board and the managers that have negotiated the business terms. So they've already gone through, this is when we want the project to start. This is what we want it to cost. This is the scope. Here's the crew. Now you take these business terms and we incorporate them. We create the legal terms to make that happen. It sounds like maybe you're a little more hands-on and you're actually negotiating. I mean, it does happen occasionally with my clients, but more often than not, those business terms have already been negotiated. And
Well, yes,
then
and that's often the case, Donna, of course, in New Jersey as well. But the proposal from the vendor isn't going to necessarily demonstrate those business terms. So, we're going to have to go back to our client and say, hey, we got this vendor proposal. Maybe there wasn't an RFP, but maybe you just exchanged, some understanding in a Zoom call or otherwise. And now we want to nail these things down. And, everybody's busy these days and everybody just wants to sign the proposal, get it over with. Yeah, we had an understanding. We have a handshake deal, et cetera. But we want to know the details. And I know you want to know the details as well.
David,
Now,
I want to interject a question because I would like you, and even if you want to use the landscape contract or a different example,
Yep.
but one of the boilerplate issues, as opposed to the business terms, but the kind of legal terms that Donna is alluding to, speak to the value of and what you would look for in provisions that establish a standard of care that they are supposed to follow, or a standard of performance that they're supposed to follow. And of course, some of these service contracts do come with warranties for the work that they do. Can you speak to that for a moment as to what you would look for?
Sure. And of course, it depends on the nature of the work. So landscape contract is probably not the best.
Well, but you mentioned the importance of licensure as something you would want, and that is a standard of care.
Well, that is a standard of care, and you're going to want to make sure that in many forms of contract that they're applying the knowledge, diligence, et cetera, which is customary for someone in a similar situation. So no matter who you're utilizing, you're going to want to make sure that at the minimum, that is the standard of care. Now, of course, I find with many of these vendor contracts, the devil is in the details.
Yeah.
And the standard of care is partially related to those specifications, because if we have certain requirements, and I'm going to go back to landscaping, pruning at certain times of the year when it's critical for pruning to happen, the standard of care is in those specifications. The standard of care is what they have to do. Now, if we're involved in a type of contract that it is not so specification driven, then we're going to want to resort more to that language that deals with a standard of care that is consistent with that practice by other people of similar knowledge and experience in the area where they are located.
Okay, and I'm going to come back to you later on some other specific contract terms, but right now I want to turn to you, Alan. I'm sure this comes as a shock to everybody listening, but not all contractual relationships work out. Sometimes you want to go separate ways. Alan, can you discuss what the association's board members, managers should do when they start to see issues with contractor performance in order to protect themselves, or at least prepare themselves for if necessary, a legal proceeding to extricate themselves from the relationship?
Yeah, so I'm usually asked to get involved where there's a problem. If it's come to my desk, then someone has a problem with someone else, okay? Whether it's the vendor having a problem with the association for not paying, or whether the association has a problem with the vendor's performance. And at the contracting stage, it's very important that your attorney argue for what's known as a termination without cause clause. Sometimes that means that you have, let me explain what that is. You don't like the way the contractor looks that day. They're not dressed right. And you just say, goodbye. We're going to give you 60 days notice. We have to pay you for 60 days and you're gone. You don't have to have a good reason. That's what you want to strive for in your contracts. But a lot of times the vendors won't agree to that. And so there's always what's known as a termination for cause provision. And when people come to me with that, and Donna talked about a way to safely extricate yourself, there are things you have to do. The first question is, what did the contractor do wrong? Let's make a list of the things that the contractor did wrong. And then we take that list and we compare it to the specifications, things that Donna and David were talking about. Is the contractor required to do that by the contract? And has the contractor done it correctly? Sometimes the contractor simply doesn't do it. Other times the contractor does it poorly. And every one of these contracts has a default provision. And almost without exception, they have a provision that says when the vendor defaults, you have to give notice and an opportunity to cure. And even if that provision's not in the contract, even if it's a 1-page, 3-paragraph contract, basic contract law requires that if the other side, the other contracting party does something wrong, that you give notice and an opportunity to be heard. I'm sorry, notice and an opportunity to cure. And that's what we look at. And a lot of times we find that clients have been sending emails back and forth between them and the contractor, and they haven't looked at the method of giving notice. We had a case where it was a high-rise residential building, and a very important component of the building were these pressure regulation valves. That's where the water is brought up in a standpipe, and these valves regulate how much pressure goes there. You can imagine a lot more pressure at the bottom because that's the source of the pressure. And by the time it gets to the top, gravity decreases the pressure. So these valves regulate. This particular manager, so our client claimed, didn't maintain these valves. And as a result, and they were required to under the contract, and as a result, they breached the contract. And when they brought it to us, because they didn't come to us at first, the first thing we noticed is there's this email thread back and forth, but that's not what the contract said is the way that you give notice. The contract required that notice be given by certified mail, return receipt requested, by hand delivery, or by overnight delivery. That didn't make it fatal. There are ways that we can look around it, get around it, but we don't want to have to address that. There are also breaches of a contract. If you want to get out of a contract, the question is, in non-legal terms, how big a deal is the breach? Lawyers say, is it a material breach? That's a big deal. If it's not a big deal, we call it non-material breaches. Basic contract law is that if there's a material breach, a big deal, and you provide the correct notice, you can get out of a contract. If it's not a big deal, if it's a minor breach, someone was at the front desk or a concierge and they showed up late a couple of days, minor breach, you can get the vendor to correct or the manager to correct, but it's not a big deal. It's not a material breach, so you can't get out of the contract. That's another thing that we look at.
Alan, a quick question. A lot of these boilerplate provisions, it calls for an uncured material breach without defining in the contract what is material. What do you do then?
So that's where you need a lawyer to give you advice about, is this a big deal? Does it go to the heart of the contract? Sometimes there are multiple small breaches, but you add them up and that becomes a material breach of the contract. And ultimately it's decided by a court. And that's a value decision that has to be made by the board based upon the advice of counsel. We can say we think that it's a material breach. Ultimately, a court will make that decision.
I would add, and I'll give you a second to chime in, David. And I would add that if your contract has gone to Alan for assistance, it either means you probably didn't have your counsel look it over before you signed it, or you didn't follow your counsel's advice before you signed it.
Yeah, because David and I are not going to allow uncured material breach to be the termination provision.
Right. Absolutely.
David, go ahead, please.
So Alan, and I know this goes a little bit beyond contracts, but what does an association do? Let's say they have a waste hauler and they're terribly unhappy. And let's say they've provided notice to the waste hauler, whether properly or improperly, and the waste hauler simply denies this, okay? And now they want to terminate that contract, but they want to enter into a new contract with a different waste hauler, which can be a pretty expensive contract. Are there any contract terms you would suggest that can deal with that issue? Because the association is left in a very uncomfortable position where they're being threatened by one contractor while entering into a new contract for the same work.
So, lawyers can put in a contractual agreement anything that a party will agree to. And if we make it clear, then there's not a dispute about interpretation. I would be very surprised if the new hauler would include a provision, although I'd recommend trying, which says if we lose the lawsuit and we have to go back to the other contractor, your contract is terminated. More likely, you would include a provision which says something like, we have 60 days to terminate you without cause. Because before you get into a lawsuit, once we digest all of the facts, and believe me, we love our clients, but we're hearing one side of the story. Sometimes when we get a lawyer on the other side and we hear the other sides, we may revise our opinion to say, you've got some exposure here. So in the new contract, I would just put a termination without cause provision, which means you can terminate for any reason. That gives you flexibility in negotiating with the old contractor to continue the contract.
So clearly, just so everyone understands on the call, if we have both a no cause termination and a for cause termination, we're always going to recommend the no cause unless the default is so extreme that we can't tolerate another 60 days of using that vendor, right?
At this point, if I can, pardon me, Alan, while we continue our dialogue, Laura, if you would put up the second poll question. And the question is, does your board have its contracts reviewed by counsel before signing? I'm sorry if that sounds like a self-serving question. I'll say that's all.
By counsel, we mean legal counsel, not a manager. Sometimes they're actually asking their managers to review these contracts in order to avoid legal fees, and it's putting pressure on managers to really step outside their comfort zone.
And I get involved. I share the business litigation section of the firm. If you want to provide more work for me, then don't have a lawyer review your contract. I promise to provide more work for me.
All right, so the answer is sometimes, and that's actually a good segue into my next question to you, Donna, because the reason they said sometimes, I'm going to guess, is because it's all about the Benjamins. Is there enough at issue in the contract? I mean, you look at a $800,000 roof replacement contract, most sensible people would have their lawyer look at the contract. If you look at a pool treatment contract that is a 5-year commitment that involves, $100 a month to come in and treat the pool, they're going to say, it's not worth it to have counsel review it. Is the price of the contract, and I want to ask you your comments on what you look for in terms of payment terms, but the first comment I'd like you to make is a more practical one, which is whether or not the price of the contract should be indicative of whether to have counsel review it.
So I'm very sensitive to budgetary constraints for my clients, and I have quite a few clients that are very small. My smallest condo client is 5 units, 5 attached townhome units, and I'm very sensitive to their budgetary constraints. So to answer your question, in the past, I've sometimes said, anything less than 10,000, maybe you don't need the Rolls-Royce treatment. However, that has actually come back because I recently had a client that signed, it was a $500 contract. You might think $500, do I need to get this really reviewed by my attorney? Okay, it was for a testing company to test their drainage pipes. The testing company did not use the proper testing methodology, and they are now up to they've exceeded $100,000 in damage because of a $500 contract. Had there been an incidental damages clause in that contract, they would have some recourse. So it really does not depend on how much, what the contract sum is. It really depends on the work that's being done, whether or not you know this vendor. And now I'm of the opinion, send it over. I may say to a client, just let me look. It'll take me 1 hour to look at the important things, which in this case, it would have been incidental damages and indemnification.
And David earlier used the example, I think, of a landscape contract. If the landscape contractor comes on your property and they don't carry, say, workers' comp insurance, and one of their employees gets hurt, who are they going to sue? I mean, you made exactly the point I wanted to hear, Donna, and I think everybody needed to hear, is that it's not the size of the contract that determines the benefit you get from counsel review. It's the potential things that can go wrong. that indicate whether or not counsel's review matters. I'm sorry for cutting in. Go ahead, please.
So you also asked about what do I look for in terms of payment terms? Well, the first thing I look for is, are you paying too much upfront? So this would be for a project. Let's say it's a lobby renovation. Are you paying too much upfront? If you're a contractor, you're paying 50% or more as a deposit, that tells me that the company or contractor you've selected may not be well capitalized. So they're literally taking your money to go out and buy the materials they need to do your job. The other thing is if you pay too much in terms of progress payments and you're left with only a 10% holdback, in some cases, this is certainly true in Florida, David, I don't know about New Jersey, but we've got contractors who feel I can leave the 10% on the table. I'm
Sure.
on to the next job
Sure.
because that makes more sense from a business standpoint. So I'm looking at that. And then for the contracts like the landscape contracts, I'm looking for hidden costs. So what is it going to cost for debris removal in the aftermath of a storm? Is that going to be exorbitant? That should be negotiated up front. Are there hidden costs? Let's take a management agreement. Sometimes there's language in there where the association is obligated to use the manager to oversee a construction project, a repair project, to handle an insurance claim. And that's all fine if you want to use your manager for those purposes. But if you don't, you should know whether or not the contract is obligating you to do that. And then
Or to pay for it either way.
right, to pay for it whether you use them or not. And some of them are quite high. It's 5% of a claim or 5% of a renovation project. That's significant when you're talking a multi-million-dollar project. And lastly, other hidden fees like permits and bonds, that gets thrown into the boilerplate and you don't think twice about it, but what is that really going to cost? And then lastly, any change orders. You want to be careful when you're entering into a contract where it says, they don't need to, the contractor or the vendor doesn't need to get board approval for change orders. Those could be significant. So that's what I look for.
Okay. David, I want to dig into this subject, and I also wanted to point out some of the other, and I hate to use the word boilerplate because it's really a term that suggests it's unimportant.
Right.
But we've alluded to insurance before. We talked about indemnity, and I always take the position that indemnity is only as valuable. One of the questions that came in is whether or not indemnity clauses have any value at all. And I guess the answer is the indemnity is only as good as the collectability of the person who's supposed to indemnify you. So one of the ways to ensure collectability is to make sure you're dealing with people that have the right kinds of insurance to provide this service. What do you look for in insurance clauses? And could it give us a couple of examples of different types of contractors and what insurances you think are vital?
Yep. So, this alone could, of course, be a half-day program that would probably put most of our attendees to sleep. But this is so critical, and insurance can be so complicated. So I'm going to try not to get into too much to the technical, but I'll try to give a good overview of what we're looking for. So let's assume we're dealing with a security contract, because there's really potential liability there that would be quite concerning. So what do we want to make sure that we see, and we will never see in the contractor's proposals, so it'll always have to be in our form of the contract. And of course, the first one, and you've already alluded to it, Ken, is workers' compensation insurance. Now in our state, and by the way, with insurance, there can be differences among states. So I'm talking from a New Jersey perspective. Donna, Ken, Alan, feel free to jump in wherever Florida may differ in some of these things.
Well, before you go into this, Dave, I just want to ask, because when you're talking about workers' comp, Florida has the opportunity to exempt yourself from workers' comp.
Well, I'm going to talk about that.
And a lot of contractors bring that to our clients saying, good news, I'm exempt.
I'm going to talk about that.
Is that good news?
No,
Yeah.
no, it's not good news. So what we're going to want to see is that, first of all, the workers' compensation insurance complies with all state requirements and is at a level that the state requires. Every year, the association is going to have an audit by its own workers' compensation carrier. So anytime there are third parties on the property where you did not get confirmation of workers' compensation insurance, guess what's going to happen? Your workers' comp carrier is going to come back and back charge you a premium for what was not provided by the contractor. So this is really critical. Now, a very interesting exception that at least exists in New Jersey, and I'm sure under most states, if you're a sole proprietor, and whether you're an LLC, you're just an individual, et cetera, you're a sole proprietor, New Jersey law says, yeah, you don't have to get workers' compensation insurance. We don't care, okay? We want you can opt in. So we're gonna want you to opt in and have that coverage. And a lot of times you're gonna get a complaint that, oh, well, that's gonna cost me, a substantial amount of money. I'm gonna have to adjust the price of my contract, et cetera. But you know what? You're going to pay for it, association, either way. And you'd rather not have a claim against your side of the workers' comp. You want it to be on the vendor side of the workers' comp. So that's a really important term.
And I would add, David, that if you're hiring a contractor to work in your detached single family home and you want someone unlicensed, uninsured, go under the radar, not get permits, God bless you. But when you're making these decisions for the association, you need to approach them a bit more conservatively. Go ahead, please.
No question at all about that. And by the way, I assume you see this in Florida, just a little side tip. We'll sometimes say, oh, you know what, we've got an electrician here and we're going to just have him do some electrical work in the clubhouse, or a plumber, or whatever. We have a volunteer who will do this work for free. That person has to be covered. Now, you may have your own workers' comp policy, but that person has to be covered. And we always recommend against that in any event, because it creates all sorts of issues if there's problems with the work or damage caused and so on and so forth.
Beware the handyman.
Yeah, exactly. So the next type of insurance is comprehensive liability and property damage insurance that we are going to look for. And the amount of this does depend on the nature of the work, but a very minimum, we're going to look for a very minimum of $1 million, usually seek $2 million and as a minimum. And I'm going to come back to this issue in a little bit more detail in just a minute. We're also going to look for comprehensive auto insurance. So we're talking about a security company. They probably are driving vehicles. Even if it's somebody who's not in the course of the work necessarily using the vehicle, but they're just transporting themselves to the site with a vehicle, we want to make sure that any accident, any injury, anything of that nature is going to be covered under the vendor's comprehensive auto insurance policy. Now we get into the issue that really can be a trap for the unwary, and that's the certificate of insurance. The devil's in the details with this. First of all, let's be absolutely clear that in your typical certificate of insurance, being a holder, a certificate holder, means absolutely nothing, okay? Doesn't do you any good, doesn't entitle you to any notices, doesn't give you any coverage. And that's what you will typically see if you do not require more than that. So what we're going to definitely want at the very minimum is we're going to want an added insured clause with respect to both the association and the managing agent. Now, here's a great example of why you never accept a contractor's proposal. They will never say in their proposal that they're obligated to add the association or the managing agent as an added insured. So, you sign a certificate, maybe it's a low level, kind of contract Donna's talking about, a $500,000, $2,500 contract. And the manager gets a certificate of insurance that says the association and the managing agent are named as additional insured. Did that do you any good? No. And the reason it didn't do you any good is because every liability policy is going to say in it, we will insure any added insureds that you are contractually obligated to add. If you do not have the contractual obligation, to have the insurance and have the added insurance provision, you can put your claim in, it will be denied. So
David, what is the cost to add as an additional insured? Because a lot of these companies say it's cost prohibitive to add you as an additional insured. It's my understanding it's not cost prohibitive.
It's not. I mean, my understanding, Donna, and this is anecdotal, so I'll just tell you anecdotally, it's around $100 many times. So, you know, for any significant contract. Now, frankly, if you're dealing with a $500 contract like you were talking about before, and it's going to cost $100, maybe you increase the contract to $600. I mean, that's fair, you know, but you want to make sure that you're covered by the other side's insurance, because if a claim arises, you want that claim to go in on their policy. You do not want it going in on your policy. So, look, we could get into the weeds on this, and I know we don't have the time or probably the interest, but there are different added insureds endorsements, at least in New Jersey, that are approved by the Department of Insurance, and they differ significantly. Now, you know, many attorneys are not experts in insurance. We know what we need to know if we're competent, but we're not necessarily going to know every detail. So you have an insurance agent or insurance broker. We'll often take the certificate of insurance that has the added insurance paragraph, and we will turn it over to our insurance agent, the association's insurance agent, and say, what do you think? They can check on the actual endorsement that's being provided. They can make sure, because one of the big jokes about certificate of insurance, I've heard numbers as high as 50% as they're faked, which, you know, contractors in today's world, you can get a PDF. If you know anything about Photoshop, you can modify easily a prior certificate of insurance, and you can add new terms on it. And it happens all the time. And if your agent goes and confirms with the insurer for the contractor, that will give you some sense of comfort in terms of making sure that it's real and it's there.
David, a point and then a question. The point is that if you look at a certificate of insurance, the typical form that is used, and you look at the upper right-hand corner, it says in big bold letters, this certificate confers no rights on the certificate holder. I don't know that you need to see any more than that to know that it's a piece of paper that really gives you nothing. I did want to ask you on liability insurance, and then I want to move forward because we're starting to run short on time, and I've got additional questions for each of you. But I do want to ask, with liability coverage, can you explain a little bit about the difference between requiring a separate endorsement for you as an insured as opposed to having a single bulk policy?
Yeah, absolutely. So let's say you've got that classic $1 or $2 million liability policy. You don't know how many other claims have been made against that policy. So if it has an aggregate total of $1 million and they already have $800,000 in claims outstanding on that policy, you've only got $200,000 left. We're going to want to make sure the full amount of the policy is available to the association and it hasn't been restricted. So that's a great point, Ken. And it's critical that we know that and that we have that direct coverage for the full amount to the association and managing.
And this, as you alluded to earlier, is anecdotal, but if you have a contractor that has a good track record of performance and not a long track record of claims, liability insurance typically is not that expensive.
That's true. Although, to be honest with you, and this does not apply in Florida, in New Jersey, snow removal contracts have become a big problem because every slip and fall case under the sun, the contractor gets sued. And, you know, very often in New Jersey, and I'm not gonna go into length because I know most of the folks on this are from Florida, although maybe some of them in the winter are in New Jersey. And I should say in the summer are in New Jersey. So very often, you know, that snow contractor is looking for limitations on insurance because the premiums they're paying could be very, very significant just because the cost of defense.
Well, since we're talking about claims, Alan, I want to come back to you now. When a contract comes to you, whether there are claims being brought by the customer against the vendor or by the vendor against the customer, what do these claims look like? What is the potential value of these claims? Because this is a critical part of contract preparation to protect yourselves. And the contractor's forms, they do things, and I'm going to be asking David in a few minutes to talk about damage limitations. But what do the claims look like?
So typically it's a claim that's brought to us by our client, and it's for this list of things that the vendor has done incorrectly. And we analyze it in the way that I mentioned earlier. Is there a breach of contract? What's the notice provision? Has the notice been made in the way that it needs to be made? But sometimes, the question that I always ask on these cases, because this is not in a contract case, the question I always ask is, how much money is it going to cost you to fix what the vendor did wrong? How much money is it going to cost? I know you're upset about it. I know everybody on the board is upset about it. But is it going to, if you have to hire another contractor to fix what your contracting party, your contracting contractor did, and it's only going to cost another $10,000, usually what I'm going to say is, I'll send a demand letter. I'll try to settle the claim, but it's not a good idea to file a lawsuit over $10,000. It just doesn't make sense. So that's the kind of thing. In the case of the high rise, the regulators, the pressure regulation valves, that was six-figure claim. That's something that the first question I asked was, what does it cost? That's something worth litigating over, especially, and we can get into this later, if you not only collect the amount of damage, what it costs you in order to repair or fix what was done wrong, but you can collect your attorney's fees and costs as well.
I want to ask you a couple specific questions in terms of contractor claims. We often see in service contracts that if you terminate early, you have to pay us 50% of the remainder to be paid to us, or some liquidated amount, or they say that our lost profits are X. What are your thoughts on those clauses as to their enforceability and whether or not they are the kind of things that you should agree to?
So liquidated damages clauses are enforceable, generally speaking, but there are certain elements that are required that be proved. And I know it's a little bit different in New Jersey. In Florida, you have to demonstrate that at the time the parties contracted, this is before any work begins, it was uncertain as to what the damage amount would be if there was a certain type of breach, uncertain as to what the damage amount would be. So the parties reasonably attempted to estimate what the damages were. And in that case, a provision like that, if it's reasonable based upon the facts at the time of the contract, that's enforceable. Let me give you an example. It doesn't really fit into this scenario, but it's pretty easy to understand. Let's take a residential real estate contract. A buyer enters into a contract. Let's say he or she has to put 25% down and the purchase price is $1 million. And it happened, and this is actually a real case, it happened in this month, this year, where prices in Florida are just going up and up and up and up. 25% down, the liquidated damage provision says that if the buyer does not close, the seller gets to keep that $250,000. Now, that to me is a clear case of an unenforceable liquidated damages provision, because on the date, these are real facts, real case, on the date that the contract was signed, it was on the market for 1 day. There were 4 competing bids. And everyone knows that the cases, the residential real estate values in Florida are going up, commercial are going down. So it's completely unreasonable to estimate that the seller's damage is going to be $250,000. In fact, the opposite is true. If the seller cancels the contract, sells to somebody else next month, the seller will make more money.
So Alan, what questions would you ask for a service provider as to what is the reasonableness or appropriateness of, say, for example, if you terminate early in a contract that doesn't have without cause termination,
Sure.
if you terminate early, you automatically have to pay us 50% of what the balance of the payments would be.
I absolutely think a clause like that is going to be unenforceable. The real damage, first of all, the idea that you can't estimate what your damages are, that concept is not correct. The measure of damages is going to be the lost profit, not the amount that is paid every month. So if you pay, let's just have an example here. If $100 is paid every month and the profit margin is 10%, the vendor knows that their profit margin is $10 a month. So if they're asking for 50% of the payment amount and the profit margin is 10%, that's likely going to be unenforceable. And that's likely a case where liquidated damages will not be enforceable. Let me just make one other point though. Even though a liquidated damages provision is not enforceable, that doesn't mean that the vendor can't sue for actual damages. In my example, the actual damages would be the 10%. When the provision's unenforceable, it goes away as if it's not there, and then the court will look at what are the actual damages. That's the 10%.
So Alan, let me ask you about a close relative to liquidated damages. And I guess this comes up in contracts where somebody has to perform something and you say they're going to start the work on X, they're going to finish it by Y, subject to matters outside the control of the contractor. And if you don't finish it by Y, you're going to have to pay, or we're going to get to deduct from the contract price $500 a day.
Right.
Even though we can't show any damages that would start to approximate $500 a day. Is that enforceable?
Well, you're talking about what we call a damages for delay provision. And the same analysis applies. It's a liquidated damages provision. The case law doesn't make a distinction between the typical liquidated damages and a damages for delay clause. They're liquidated damages. So if it just depends upon the facts and circumstances of the particular case. And that's why, litigators get involved, because there's no simple answer. Everybody's got a little bit to say on each side of the versus side.
Well,
hang on one second, please, David. Laura, while David is questioning us, can you run our third poll question, please? Go ahead, David.
A typical example, that we would see come up is, okay, we're going to do some work on the gym, and we want to make sure that it opens by X date, because the owners are all, particularly coming out of COVID, they're clamoring, they want to use that gym. We're getting new equipment. The contractor, the vendor is going to provide new equipment for the gym, and it arrives a month late. And, the board is outraged because the owners are outraged and they're all over their tail. Did you say to them, well, what did you lose in terms of provable damages? And the answer is nothing.
Well, so let me just give you a thought on that, okay?
Sure.
One way to analyze the damage claim in that case might be a loss of use claim. And I don't know how valuable that is, but one way, I'm sure you can find an expert who will opine on that. How many people use the gym? What would it cost them for monthly gym fees? Something like that, something at retail value. So one way of looking at it from a liquidated damages provision is, if there is a liquidated damages provision, which is damages for delay, what would be the loss of use claim? Now, I don't presume to know exactly how to calculate that. I can give an expert some ideas, but somebody will be able to come up with that.
Along those lines, and I'm sure, Dave, you've seen this, how many vendors will agree to set off for irritation purpose? I mean, I've had clients come to me and say, we're not going to pay X, we're taking 10,000 off because we were very frustrated and irritated, and their work was, they did the work, Alan, but it wasn't to their satisfaction. So it wasn't, perhaps they didn't do it to the full scope outlined in the contract. I've never had a contractor agree to a set-off provision. I think you need to determine first if you've got the right to set off before just simply saying we're not going to pay, the remaining 15% because we weren't happy with the results.
Absolutely correct, especially if there's a prevailing party attorney's fees in the contract provision. And we can talk about that in a moment.
So The response to the last poll question was that 82% have not sued or been sued involving a contractor. And I suspect of the 18% that have been involved, they probably involve construction contracts more than service providers. And I'm hoping that what we can all glean from that is most of you follow the advice that Alan just articulated, which is before you go into expensive litigation, you need to decide if it's worth it.
Well,
Now,
the 82% are our clients, Ken.
That's why Alan feels like the Maytag repairman most days.
Exactly.
We have only about 10 minutes left, so I wanted this to be a little bit rapid fire. Donna,
Just one thing, unfortunately,
Pardon?
Donna, unfortunately for our clients, I have plenty of work because they don't come to us in advance.
Yeah. Well, most did say sometimes they send the contract to counsel. You know, Donna, my last question for you pertained to indemnity provisions, which we've spoken of at great length. But you mentioned the quest for fairness in these contracts. You could take indemnity provisions, you could take insurance provisions. What are the typical provisions that you see where people tend to overreach into being unfair? And you can start with indemnity by way of example, because we've spoken, for example, about some of the elevator service contracts.
Well, I want to raise elevator, and I'll do this as rapid fire as possible because I know we're coming up on the hour. Alan made an excellent point early on. Indemnification provisions have somehow over time been accepted as just, okay, yeah, there's going to be an indemnification provision in the contract without understanding how subtle some of the inequity can be. Let's take an elevator contract. Think about this. We have to fight. Those contracts typically come out with just a unilateral indemnification, which is association, you're going to indemnify the elevator company for anything that may go wrong that gets the elevator company sued. Now, we have to fight to just get that to a mutual indemnification. But if you really think about it, it's a little outlandish. What could an association do that would really get the elevator company sued in terms of negligence? Somebody pushing the button too many times on the elevator. I mean, the elevator company is the one that has to make sure that that elevator is running, that it's to code, that it's maintained and it's repaired. I've got communities where we have elderly people on the upper floors. If an elevator goes out, we've got real problems. So those indemnification provisions, number one, sometimes they're outlandish, particularly with elevators and security contracts where the association has to fight to even get to a mutual indemnification. Then we need to look at what's the threshold. Often if you get to the mutual indemnification, the vendor or contractor wants you to, they only want to have to indemnify the association if they are grossly negligent or they commit or there's willful misdeeds. That's a very high threshold as opposed to general negligence and misdeeds. So the first thing I'll always do is I will lower that threshold. If they're asking for gross negligence, that's just a bridge too far, in my opinion. The same thing with willful misdeeds. Now, I think your contractor, the company you're doing business with, should be willing to indemnify you for their negligence. It doesn't have to rise to the level of gross negligence. They should indemnify you for their misdeeds. I don't think it has to rise to the level of willful misdeeds. And
Donna, do you take that position also with regard to management contracts?
I do.
Okay.
I do, but you know, they are acting as our agent. So again, you know, I will give on that because they are the agent for the association. My starting point would be negligence and misdeeds, but I'll normally give on that because they are, you know, they do take direction from the board. But that's why it's important to make sure that your scope of authority is really fleshed out. So when we're talking about indemnification, what are we really talking about? Managing risk. What's the risk of the association getting sued? The risks are obviously going to be higher with a security contract. They're going to be high with an elevator contract. There's, you know, and less so with other types of contracts. And then lastly, there's some very subtle provisions that you really have to think about. Lately, I've been seeing some indemnification provisions that say that the contractor or company will only indemnify if they've been adjudicated solely responsible. Now think about that. So if this was a premises liability case and a jury found that company 99% liable for the damage or the injury, and the association 1%, under that indemnification, that contractor would not have to indemnify because they were not adjudicated to be solely. And then lastly, I will just say, the term adjudicated means adjudicated by a trier of fact, not your board. It doesn't mean your board has adjudicated that contractor to be reliable. It means a court.
Donna, even when it says solely negligent and it doesn't go into the adjudicated language, which I've seen, I always push back on that because, I usually argue to the other side, well, maybe we were negligent in hiring you. So,
David, I want to segue to you.
Yeah.
And again, we're sort of in a rapid fire state here because it's 1 o'clock now, but
Understood.
Damage limitations are typical. And I see them, for example, in security contracts where you got people, let's face it, in some cases carrying guns on your property. What are the typical contracts where you need to be on the lookout for a cap on the contractor's liability for damage?
Yeah, so let me just further describe that a little bit quickly. You will typically see, in what you're talking about, Ken, you will typically see we are not liable to the association for anything more than the amount of consideration we're being paid by the association. And you see this in security contracts, you see this in a lot of professional services contracts. Engineers, architects will commonly put that in. And I mean, just take an example of an architect or engineer who you're hiring to prepare the plans and specs for a major job, and they prepare the plans and specs. That's fine. You bid out based upon those plans and specs. The work is done. Turns out the work is bad. It's not that the work was bad. The design was bad. Are you going to be satisfied with $15,000 if that's what you paid your engineer or architect for preparing the plans and specs? Absolutely not, obviously. But so we always take those clauses out. We always refuse, and you're going to get a lot of pushback with some contractors. And
another typical damage limitation that I'd ask you to speak to briefly is that we are not liable for consequential damages.
Yeah.
What are those?
So consequential damages are damage to something else other than the work of the party that was hired by you. So as a consequence of the damage, you hired a sprinkler. Well, I don't want to get into too much into construction, but you hired, let me use this because it did come up recently. We had somebody doing maintenance work in the property. They had the individual employee had a ladder. Accidentally, he hit a sprinkler head. Water poured out of the sprinkler head, caused over $250,000 worth of damage to the property. Is our damages going to be limited to putting the sprinkler head back on? No, but the consequence of that accident, which is what it was, is that we have $250,000 worth of damages on the property. So, if somebody says, I don't want punitive damages, we'll give on that. I mean, sometimes there'll be limitations on punitive damages, but when it comes to consequential or incidental damages, no, because that can often be the large part of the claim.
And apropos of Donna's comments on indemnity, contractors who want to limit their exposure for damages, what is the message you take from that? Which is that they're not willing to stand behind their work, and they're not willing to stand behind the things that their people do on your property and be responsible and step up if they cause you a problem.
Well, the other thing, I agree with you on that. But I'll tell you the other thing that I think is really the influencer on that. That contractor has liability policy. That contractor is being told by its agent that if you include these limitations on damages, your premium is going to be a lot less. If you don't include them, then your premium is going to go up substantially. And I'll get contractors all the time who say, well, my agent says I can't. No, the answer
is not what they're saying.
That's not what they're saying. They're not saying you can't. They're saying you're going to pay more for insurance.
Which is, of course, for our clients, not our problem.
Right, exactly.
Alan, maybe the boilerplate that people care the least about and spend the least time reading are the provisions at the very end of the small print on the back page, in the smallest font imaginable, dealing with applicable law, venue, and costs and attorney's fee provisions. Are these provisions important?
Well, it's, from my perspective, it's one of the first things I look at. Let's assume for argument's sake that you've looked at the contractor is breached, you've made the list, you sent the notice in accordance with the contract, and you're ready to sue the vendor because you're out, let's say 6 figures. The vendor is an elevator vendor, maybe they're in Schaumburg, Illinois, and their contract says that venue is the place where you're allowed to file suit, is some county in Illinois.
Cook.
Guess what? That's enforceable. You have to sue them in wherever whatever county Schaumburg, Illinois is located.
And this contract will be interpreted based upon the law of the state of Illinois.
It's Cook County. I used to go to the mall there all the time, the Woodfield Mall.
Okay.
I don't know how you pulled Schaumburg out of the air, but
I
bravo.
have no idea. I knew you went to the mall there. So, and Ken also mentions what state's law will apply. The parties can choose that Illinois the law will apply, not Florida law. And that presents a couple of issues for you. You're going to have to hire an Illinois lawyer familiar with Illinois law. When you file that lawsuit and you are the plaintiff and you go to trial, you're going to have to travel to Illinois, not just for trial, but also for your depositions. Now, it's a lot easier today with Zoom depositions, but when that goes away, unless the court approves it, you're going to have to travel there for depositions and certainly for trial. And as to attorney's fees.
Well, but before you go to attorney's fees, bear in mind, if you have to go to a trial or a depo in Illinois, Donna's thinking they're going to probably schedule it for February.
Exactly. If there's no venue provision, generally speaking, you can sue the defendant where they reside or where the breach occurred. So you would have a choice between Illinois and Florida in that case. The breach occurred in Florida, the work was in Florida. But with a venue provision, you always want the venue to be wherever you're located. That's where your witnesses are, that's where your lawyers are, and you want the law of that state to apply wherever you're located. As to prevailing party attorney's fees, this is a double-edged sword. If you're representing a client, I would say, generally speaking, we want to include those provisions. That means that if you win the lawsuit and you prevail on the substantial issues in the case, the other side has to pay your attorney's fees and your costs. And that puts you in the place that you were after you recover damages had they not breached. So I think those are all very important provisions to look at.
And
First thing I look at is whether there's prevailing party attorney's fees.
And certainly the prevailing party attorney's fee provision factors into the first comment you made earlier this afternoon, which is if you want to pursue a breach, is it worth it?
Exactly. It's the first thing I look at. What law applies? Where do I get to sue? Is there a prevailing party attorney's fees provision? Because as you say, that's exactly the question I present to the client. Okay, you have a claim for $25,000. Is it worth it? You get your attorney's fees if you win. How much time do we have to spend on this?
So Alan, sometimes in that small print that Ken referred to, there will be an arbitration clause. And often it won't be particularly detailed. It will just say if there's any dispute between the parties, such dispute shall be arbitrated. What's the problem with that?
So there are a couple of things. First, the parties, there's no designation as to whether AAA or some other arbitration entity will be the arbitrator. Now, arbitration provisions, in my view, I don't like them, okay? The only time I like them is if I'm representing a client that doesn't want to make this dispute resolution process public. You might be a major corporation and your employees may sue you. You don't want that to be in the public. Arbitration's private. Right? But for my purposes, I always want to be in a courtroom, because the problem with arbitration, not just the one you mentioned, which is a drafting problem, there are no appellate rights. If the arbitrator, if it's one or a panel of three, make a mistake, you can't appeal unless you haven't been given enough notice and an opportunity to be heard. Due process rights are taken away, and that's never the case. So you are agreeing in advance that this panel is the end of the road, or this arbitrator, one person, is the end of the road, and it's over, and it's confidential. So I've given you the examples where I like it only when my client wants to keep things confidential. Otherwise, I much prefer the courts, because the judge has to look at the appellate court cases, and no judge wants to be reversed on appeal. So you have some control over the outcome of the process.
Laura, let's do our final poll question while we get into final thoughts. And I want to thank the nearly 400 people who've stuck with us for the entire hour plus. And this question is, where you have contracts that have automatic renewal provisions, which is common, do you have a system that tracks them the same way that you would calendar, your doctor's appointment or your dentist appointment or your friend's birthdays?
Ken, why don't you explain what that is?
An auto renewal provision is a provision that provides for a contract that was, say, for a term of 5 years, to say that if you don't give us notice of termination at least 60 or 90 or some specified number of days, give us notice in a certain manner before the expiration of this term, the contract automatically renews for another term of the same length on the same terms. And some of them even have clauses that provide for an escalation of the fees that you're paying. So having contracts with automatic renewal clauses is something that, quite frankly, in my opinion, and I think my colleagues on the panel share the opinion, is something to be avoided. And the response to the poll is that it's roughly 50-50 for people who follow up. If you sign these contracts that have auto renew provisions, you have to be mindful of the dates. And you need to calendar them in a way that protects the association, because the management could be different, the board could be different whenever the contract expires.
Not that hard. It's not that hard.
No, it's not in this day and age.
No, it's not that hard just to renegotiate when the year is up. A lot of them say, oh, we need this auto renewal, because it's not that hard. When you see you're coming up on expiration, just sit down and renegotiate a contract.
And with that, Donna, I'm going to start with you on final thoughts.
Okay, because we're way over, I made a list of do's and don'ts. Okay, you ready?
Okay.
Do get your contracts reviewed by legal counsel. Don't sign a contract without the full board's approval and knowledge. And this is for my board members, where you've got one member of the board who feels confident that he or she's making the right decision, signing a multi-million-dollar contract, and no one else on the board knows about it. So please make sure that the board knows that you're signing this contract. Do undertake your due diligence and the RFP process if it's required. Don't sign major contracts within weeks of an election. I know boards do this. They're coming up on election. I think it's bad form. If it's a good contract, if it's a good service, then, and you haven't done it well before the election, then let the new board undertake that contract. And then lastly, please don't pressure your manager to serve as your lawyer when it comes to reviewing, negotiating, and signing contracts. If the question is there a liability if? That's a legal question that needs to be posed to counsel. And also, using the retired personal injury attorney on your board is probably also not a good idea with these contracts.
Thank you, Donna. Thank you, Donna. David, your final thoughts.
So one thing we didn't talk about, and is critically important, as we know as lawyers, is that you follow the proper procedure in awarding a contract and approving the execution of the contract. And while there may be some differences in statute between Florida and New Jersey, I'm pretty sure that in both states, there have to be approval in a vote before the membership. At least that's true in New Jersey. And here's what I see happen all the time. We're in between board meetings. Oh, we got to get this contract done. Okay, board votes by email. Okay, they're approving the contract. They're approving the board president to sign the contract. And then comes the next meeting when you would hope they would ratify and confirm the contract. And by the time the next meeting rolls around, they forgot about it. And when you get into court, very often, one of the things the judges go on to see is, where in your minutes was this approved? And when you can't show that it was properly approved, there's a problem. So process is important.
Thank you, David. Alan? Final thoughts?
Yes. My law school professor, and I went to school in New Jersey, for wills and trusts, taught us that when you're drafting a will, you assume that before your client leaves the office, your client is going to drop dead. That's how you think about a will. And what I'm saying to this group is, when you're negotiating with a contractor and you're entering into a contract, you should think about that contract as if one day after it's signed, the contractor is going to breach the agreement. Doesn't matter how good you feel about the contractor. That's how you look at these contracts.
Thank you, Alan. My final thoughts are short and sweet. Boilerplate is a term that is designed to deceive you into thinking that these provisions are not important, that they're standard, that that these provisions deal with mundane, nothing issues, and nothing could be further from the truth. Read the whole contract. Make sure you understand what the provisions mean in the real world. And with that, I want to express my sincere thanks to the people who joined us and stayed with us the whole time. I want to thank my partners, Donna Berger, David Ramsey, and Alan Levine, for joining me, for presenting what I think was a very lively and informative discussion. And with that, I will say good afternoon and thank you.